welcome to the I Got Fired show for folks who have been fired or afraid they might be. My name is Tom Spiggle, the founder of the Spiggle Law Firm and the host of this show. And today we are going to be talking about, we're going to have a series of shows for federal employees, focusing on the rights and tactics that federal employees can use when they are in trouble at work. And today I am pleased to have joined me in over the next several of these shows, Rob Porter, who is an attorney in my office and has years of experience working with federal employees. He is a University of Chicago law grad, and we're pleased to have you with you, Rob. I'll let you tell us a little bit about yourself.
Hi, my name is Rob Porter. I've been practicing law for over 10 years, and for 5 or 6 years, I've been an employment lawyer representing employees in the DC area, and much of that time has been representing federal employees. So yeah, I'm excited to get started on this podcast.
Yeah, that's great. Well, listen, what we're going to do today is we're going to kind of have an overview of the legal landscape for federal employees, and in particular, how it is different in important respects from those in the private sector. So why don't you tell us a little bit about that? What are, just in broad strokes, some of the differences, and some of the topics we'll be discussing here will be the ones that we will be drilling down on in later sessions. So I'll let you get started. What are, 50,000 foot view, what is different if I'm a federal employee versus if I'm in the private sector?
Okay, so generally speaking, federal sector employees have more robust rights and protections. The federal government strives to be a model employer, although it doesn't always succeed. And unlike private sector employees, federal sector employees have statutory and regulatory rights that protect them before the government can take some action, like suspending an employee without pay or demoting or firing an employee. They have to follow certain procedures. So that is one big difference.
Yeah, because in a private sector, within reason, as long as they're not violating some state or federal law, they can suspend you without pay. They can, they can fire you without notice. There are any number of rights that you don't have in the private sector. And I think most federal sector employees understand this, but it's important to keep in mind that, if you're talking to your friends who have private sector jobs, that it's a completely different landscape. Even though the same federal laws apply, for example, Title VII, Fair Labor Standards Act, all those laws also apply to federal sector. But as you mentioned, there are a number of rights that federal sector employees have that those in the private sector don't. Talk to me a little bit about, the Constitution and how that applies differently to federal workers and those in the private sector.
So one of the reasons and maybe the big reason why federal employees are different is that under the Constitution, that they have a property interest in their continued employment with the federal government. And so they're entitled to due process under the 14th Amendment before the government takes that right away, which means that if the government is going to fire someone, a federal employee, for example, that they have to give that employee due process under the 14th Amendment before they can do that. Now, a private sector employee doesn't have that protection. Their company, their employer, may have internal policies, that we have to place the employee on a performance improvement plan or do this or that before they're fired. But those are not laws. Those are just internal guidelines or policies that even if the employer doesn't follow them, it doesn't necessarily give the employee any kind of right to sue or appeal. But federal and sector employees are different. Their rights come in part from the Constitution, And so that's one important difference.
Yeah, absolutely. And another one is the First Amendment. For private sector employers, we did a couple of blog posts and some other information on our website about the protests in Charlottesville, in which a number of those protesting were, at least one person in the news, as reported in the news, was later fired for attending that. And a lot of people are like, well, hey, what about his First Amendment rights? And this is a common misconception, even among attorneys, as you well know, Rob. A lot of people are like, well, what about his free speech rights? But the First Amendment does not apply to private sector employers. So he had no free speech rights. And as long as the employer enforces its policy evenly, they can, within reason, fire you for some things that you can say in or out of work. I mean, there are some restrictions, of course, on the National Labor Relations Act, but we won't get into those weeds. But it is different from federal sector employees. Do you want to talk just a little bit about that?
Yeah. So the First Amendment restricts the government from prohibiting or limiting speech. So it doesn't stop a private individual or a private employer from taking an action against someone for speaking out on a particular issue. But the government is different, is a different animal, and so there are more robust protections for federal employees when it comes to speaking out, because again, it's the federal government who's taking the action against them in the capacity of an employer, but it doesn't change the fact that it's the federal government.
Yeah.
And so, yes, that's exactly right.
Absolutely. All right, and we're going to talk about each of these individual topics in later shows, so I'm not going to ask you to really get in depth, but so for people have an overview, talk to us about, okay, so I'm a federal employee, I am in trouble at work. There's the MSBP and there's the EEO process. Tell me what those are and how they differ. Again, understanding we're going to talk about them more in depth later, but broad strokes, what are they and why does it matter?
Okay, well, let's just start briefly with the EEOC. It stands for the Equal Employment Opportunity Commission, and private sector and public sector employees can avail themselves of the EEOC. And it is an agency that's created to handle claims of discrimination and retaliation, harassment. And so if an employee is alleging that they are being discriminated against by their employer on the basis of what are called protected classes, like their race, national origin, religion, their gender, then they can file a claim with the EEOC. Now, in the private sector, you have to file first with the EEOC, and most likely all that it will do is issue you a notice that you can, after it does an investigation, which in my experience, it's a pretty watered down and disappointing investigation. They give you what's called a right to sue letter, where you have 90 days to file in court. And that's if you're a private sector employee. If you're a public sector employee for the federal government, it's the process is very different. For one thing, while private sector employees have 300 days after an incident to file with the EEOC, in the federal government employees have to file within 45 days, so it's much shorter. However, there are many more rights that federal sector employees have because the investigation that's initiated once they file a complaint is much more substantive. There is a report of investigation, a big, thick book, sometimes multiple books, containing all sorts of information related to the claims that are produced at the end of this investigation. And the employee will be able to take that and look through it and determine how strong or weak their case may be. And then once they they have that report, they can go on and do what's called request a hearing before an administrative judge in the EEOC. Now, private sector employees can't do this, but a hearing in the EEOC is basically a trial, and administrative judges are essentially they take the role of judges with more limited power than an actual member of the judiciary has, but they decide cases and determine whether an employee has been harassed or some other action has been taken against them for a reason, for a discriminatory or retaliatory reason. And very often, but not always, the EEOC is more favorable to employees than court might be. So public sector employees can still go to court. They can take their case out of the EEOC and go to court if they don't like the judge they have, or they want a jury, or whatever the case may be. But generally speaking, the EEOC is a more favorable process for employees. So that's the EEOC process in a nutshell, and how it's different for public sector employees. Again, private sector employees cannot get in front of an administrative judge in the EEOC, and they don't get a big bound volume with all kinds of affidavits and emails and other documents related to their claim. But federal sector employees have the advantage of those things. And the other thing you asked about was the MSPB. That stands for Merit Systems Protection Board. Now, this is something that's exclusively for government employees. Private sector employees don't have anything like this. And basically, the Merit Systems Protection Board makes sure that the government, when it takes an adverse action against an employee, it suspends an employee without pay, it decides not to hire or promote an employee, it decides to fire or demote an employee, that it follows the proper procedures and rules. And unlike the private sector, where a company might have written policies and procedures that they should follow but don't always, these rules are laws and regulations that the government has to follow. So before it fires someone, it has to put them on notice about what it is proposing to do and the reasons why it's proposing to take that action. And then the employee has a chance to respond, and then a decision is made. And once that decision is made, let's say the decision is made to fire an employee, then the employee can appeal to the MSPB. And there they go before an administrative judge, similar to a judge in the EEOC, in that they function as basically any other judge, but they have more limited authority related just to MSPB claims. And the employee during the MSPB process would have the right to request all documents and even do take a deposition or two related to their claim. So it's a lot like litigation.
Yeah. And
so that's the MSPB process, which again is something that only federal sector employees have a right to.
Yeah, absolutely. So as I understand it, so if I'm a federal employee and I think I have a hostile work environment claim because they're treating me differently because I'm a man or a woman or a particular race, then that would go to the EEO. Is that right? That's
right. So you would have to file in the federal sector. You would have 45 days. From what you're talking about is a pattern of harassment. You would have 45 days from the most recent incident to file a claim. Yes. So you would not go to the MSPB for that. You would go to the EEOC. And then again, that would start the investigation process and potentially lead to a case before an administrative judge.
And then it would be different. I would go to the so if I'm a federal employee and my manager comes to me and says, you've been late 8 days a week and now I'm going to fire you, or I'm going to put you on a performance improvement plan, then that is something that I would have to take through the MSBP. Is that correct? Because I'm not making an EEO claim. I'm just saying that my employer is not following the proper procedure or has gotten this wrong about me being late. Is that right?
Right. So if the employer is taking an action against you, and it's not really discriminatory on the basis of not treating you differently on the basis of your race or anything like that, but is just not properly following the rules. Maybe your employer is claiming that you're not doing a good job when you have when you are, and you have a lot of evidence of that. Then you would file a claim with the MSPB only after the action is taken. So the MSPB would be the place where the employee would appeal to after the adverse action, such as suspension without pay, was proposed and then actually decided upon. So once that happens, yes, you would go to the MSPB and you would argue that the government didn't follow the right procedures. I wasn't told that this was a requirement, or I wasn't given an opportunity to improve my performance, or even simply my supervisor just has his or her facts wrong. I did exactly what I was supposed to do, and I'm not, my performance isn't deficient. So those are all the sorts of arguments that you make in the MSPB. Whereas in the EEOC, you'd make an argument that you were treated differently, or that you were being harassed because of your skin color or country of origin or something like that.
Yeah. No, and then so the MSBP process is one of the, well, there are many differences that you've just laid out, but the MSBP process just does not exist in the private sector, right? I mean, like if you're private sector, if your boss comes to you and says, you were late 8 days a week and I'm going to fire you, they're entitled to be wrong. They're entitled to be unfair. And as long as they are not discriminatory or otherwise violating a law, that's not illegal for them to do that. Whereas it might be in the federal sector.
Mm-hmm. That's right. I mean, private sector employees are at will. And so unless they have a contract that says you can only fire this employee for the following reasons, or you need good cause or something like that, then your employer can fire you for any reason, so long as it's not an illegal reason, such as discrimination. Right. And that's true even if even if their policies say that, employees should be placed on a PIP, or they should be given a certain amount of notice. Even if the employer doesn't follow its own policies, that doesn't necessarily give the employee much legal standing to sue or to fight back if they've been fired.
Great. Let's talk just a little bit about the differences in finding a lawyer if you are a federal employee. I mean, of course, you can use the same sort of resources that any other person can in terms of finding a lawyer. But talk a little bit about the jurisdictional limits, if any, on finding on having somebody represent you in the EEO or the MSPB process, and then talk to me a little bit about the differences in terms of what a lawyer needs to know when representing a private sector employee versus representing a public sector employee. Does those make sense? Mm-hmm. Okay, so start with the first one. If I'm a federal employee, I'm looking for a lawyer. How is my situation different than somebody in the private sector who might be looking for a lawyer?
Okay, well, I think the most they're similar, and obviously you're looking for a lawyer, and you probably want to find a lawyer in your area. But if you're a private sector employee, a public sector employee, then you should look for a lawyer who's experienced doing public sector work, because it is, there are very specific and unique statutes and regulations that protect and pertain to federal employees. And so someone who is just an employment lawyer but represents really exclusively private sector employees wouldn't necessarily have the expertise necessary. I mean, there may be some overlap in terms of the law, but it takes someone who has real experience and knows the ins and outs of the process, because it can be a very confusing process and it doesn't always make sense, and it can be frustrating for lawyers and clients. And so it's important to have someone who's gone through that before and done it before. In terms of bar membership, I'm not sure that you even need to be a member of the bar to represent someone in the MSPB or the EEOC. Whereas in the private sector, if you're filing something in court, you have to be a member of the bar in that state or jurisdiction. So that's another difference.
Well, and I, for example, if I understand that correctly, if I'm in Oregon, I'm a federal sector employer, I could get a lawyer in DC where we practice, and that person could be my lawyer even if he or she is not barred in the state of Oregon. Is that right?
Yes, that's right. And it might be a good idea, even if you're way out on the West Coast, to get a lawyer in this area, because this area, the DC area, is, as you know, it's no surprise, is where the most experienced federal sector employees are, because most federal employees are in this area. And so there's not much probably work for an employment lawyer who specializes in federal workers out in Iowa or Texas necessarily, but yeah, you can do that work exclusively really here in this area.
And so I think you alluded to this earlier, but my understanding is that you have to be careful in the MSBP, or even the EEO process, but particularly in the MSBPs, because there are some very short and very arbitrary deadlines, hoops you have to jump through, that if you are not, that do not exist in private sector and private sector work, that if you're not aware of them as an attorney, that you can end up in missing some important deadlines.
Right. There are a number of different places along the way, along the administrative process in the EEOC and the MSPB, where the employee has choices to make, which way to go. Do we request a hearing at this point? You can also request a decision from the agency on your matter, for example, and you have a certain amount of time to do that. And there are a number of ways that, and in terms of, if let's say you're a public sector employee, you file a claim and the claim is rejected. What do you do in that case? So there's a number of ways, a number of places where it really pays to have someone who knows the lay of the land, who knows the way around the administrative process, and even knows which administrative judges are more favorable to employees, which ones are less favorable, because an experienced lawyer could tell a client, look, this judge has a reputation as being extremely friendly to the agency and hostile to employees. You might be better off filing in court, for example.
Right. No, okay, that's great. That's very helpful. Well, we're gonna end it here for our overview. I appreciate it, Rob, and then we are going to be in the subsequent episodes talking more in depth about these topics, and our next one will be on performance improvement plans, but we will let folks tune into that next episode. Thanks, Rob.
Yeah, thank you.